All right, it is October 29th, which means first I have to say happy birthday to my big bro, Awad. It is his birthday, and it's Halloween weekend. I hope you guys are ready for a great and safe weekend. I'm Attorney Mubarak in downtown Orlando with Mubarak Law, and today's Facebook Live is on Friday, so normally we do it on Thursday, so thanks for joining us on this changed schedule. Really quick updates before we get started with our law guest to continue to educate you all on different areas of the law. Some updates on immigration and PI. First, earlier in the week, the Biden administration released the official memo with the details regarding the lifting of the travel ban for vaccine folks coming from abroad. It's basically stating that if you are vaccinated and you take your tests, you would be allowed to enter into the United States. That's great news for Central Florida and for our business industries and the tourism industries. Now it lifts the general bans that they had for countries specifically, like their UK or Europe. Those bans are gone, and it's now going to be based on vaccinations. If you are a U.S. citizen or a permanent resident, you are going to be required to be tested on your way home. There is some changes in the policies for that. We did post the memo on our Facebook page, so if you want to see it, go ahead and check it out. And then I want to go ahead and give you guys some information about our guest. We have attorney Charles Smith from downtown Orlando as well, joining us, who passed the Florida bar and was admitted in 1996. He graduated from law school from the Indiana University Robert McKinney School of Law in '96, and he is a very experienced trial attorney where he has taken over 60 workers' compensation cases to trial. He's admitted in several different areas, the District of Columbia, the state of Iowa, Florida, and he is active in the Central Florida Trials Lawyers Association. I'm going to bring him on to discuss what he does. And for many of our clients who are unaware about your rights when it comes to workman's compensation or first-party insurance, I hope that we're going to be able to provide you with some information. So I'm going to go ahead and bring on Mr. Charles Chuck Smith. So, hey, Chuck, how's it going?
It's going good. How you doing?
Doing well. Thank you for joining us today. I know you had a busy day. You were at a mediation, I believe.
Yes, just got done right before this. So,
okay, hopefully it went well for you and your clients.
Yes.
Okay, thanks. So Chuck, so you do several different areas of law. I see first-party insurance, workman's compensation, premise liability. Can you tell us a little bit about those areas and what does that mean in layman's terms, or for those who are not familiar with those areas of law?
Sure. Well, the first-party insurance claims would be a lawsuit against your own insurance company. So I'll sometimes get phone calls from individuals who were in a car accident and their car was damaged, and they want to sue the other insurance company because the other insurance company isn't paying enough for their vehicle. And I have to explain that's something you could do. Well, technically you'd sue the other driver, but you can't sue the other insurance company under the non-joinder statute. But you could sue your own insurance company if they refuse to pay for the damages if the other insurance company isn't paying for them and they carried comprehensive or collision coverage, which would be the two coverages that cover your own vehicle. You can also, first-party insurance claims would include homeowners claims, uninsured motorist claims, PIP claims.
The homeowners claims, does that include things like hurricanes or storm damage?
Yes. Yeah. As long as, and I'm going to assume, I think all of the policies include hurricane and storm damage. Technically, you can buy, if you don't have a loan on the home, you can buy whatever kind of insurance you want. I'm sure there's other insurances you could get, but they almost all include hurricane and storm damage, as well as accidental damage, like from a pipe bursting or somebody falling into something and knocking, a bunch of stuff over in your home.
I see another thing, a couple things in your bio that's very interesting to me. So I might nerd out and ask you a lot of questions, and I'm sorry about that. But I see here that you have civil rights cases like school negligence and things like that. Can you explain a little bit, give us an example of what that might look like?
a school has a responsibility to, look after your kids when you're leaving your children in their care. So a school negligence case normally involves some kind of injuries occurring to a child based on the negligence of a teacher or supervising, staff members. So I've had clients who had a client who was beaten up while two teachers' aides watched and did nothing. The whole thing was on video. And I've had a lot of clients who were injured, because of negligence of a teacher. And those are just standard school negligence cases.
Are schools subject to like any type of sovereign immunity or caps on coverages? Like if you're hit by a police officer vehicle or a bus, is there kind of limitations on recovery for those types of cases?
In most circumstances, yes. So if it's a simple negligence case, then you're stuck with sovereign immunity with the $200,000 cap and 25% cap on attorney fees. The exception with the schools would be for essentially deliberate indifference. And that you have to show a deliberate indifference to the safety of the children. And you can show that through an ongoing practice or policy, or just like the case that I told you about previously, right, with the teachers literally watching as the whole thing goes.
That's what I was about to ask. That sounds like that might be a good argument to make with that type of standard. And was that successfully proven or established that it was deliberate indifference? That
case got resolved before it got to that point. But technically that would also put you in federal court as well under the civil rights violation, deliberate indifference.
Okay.
And civil rights cases also encompass, excessive force, false arrest, things of that nature as well.
So what would you say is one of the largest, or tell us a little bit about workman's compensation? What is the difference between a personal injury, slip and fall? We handle those in our office, but we don't handle workman's compensation. What is the difference regarding workman's comp? Can you explain that to anybody who might be joining us? And for anybody watching, I see there's a couple of you. Please feel free to ask questions. I'm sure we'll try to get to them. And I think somebody has a comment. Mahmoud, hey Mahmoud, how you doing? Thanks for joining us. And go ahead, Chuck. Can you tell me what workman's compensation is?
Sure. Workers' compensation is statutory. In the state of Florida, if you're working for either a construction company or a private employer with more than 4 employees, other than the federal government, then you would be covered under the Florida Workers' Compensation statute. Your employer is supposed to be providing workers' compensation insurance. Workers' comp is different than personal injury. In a personal injury case, you've got pain and suffering, you've got emotional distress, you've got your compensatory damages. In a workers' compensation claim, the damages are all statutory. So you have lost wages and you've got medical. The insurance company is supposed to be providing you with medical care per the statute requirements. And then lost wages get paid if the authorized doctors are taking you out of work or putting you on a light duty status. And there's sometimes when we can challenge that with an independent medical exam or trying to get a change in physician. But generally it's disability and lost wages, disability, and medical.
But does that injury have to happen while somebody's working? What is like a typical factual scenario that you see very often? So that, besides the medical treatments and the care and the damages, but just to let somebody know when they may have a potential workers' compensation case.
And that's a little more complicated of a question because you can have a repetitive injury like carpal tunnel. So if you have somebody who's working as a transcriptionist or doing data entry or doing plastic molds, folks who do plastic molds tend to suffer from a lot of carpal tunnel complaints because it's constant popping and snapping of the plastic. So carpal tunnel is repetitive injury. Most injuries are traumatic. Somebody trips and falls. Somebody picks something up and their back pops. Technically, if you're on the job driving, then a car accident can actually be both a personal injury case against the other driver if there's somebody else at fault, as well as a workers' compensation claim.
We actually have a case just like that. He was working for a rental company, and while working within the vehicle, was in a car accident. So it's actually before I met you, Chuck, but we have the personal injury case, the car accident case, and then somebody handling the workers' compensation portion of his case. So thank you for pointing out that you could pursue, in some scenarios, have 2 claims essentially.
Correct. And then workers' compensation would have a lien against recovery against bodily injury recoveries. Oddly, the lien doesn't apply against uninsured motorist coverage, but it does apply against bodily injury recoveries. And technically, we say if you're going to get hurt on the job, that's the best way of it happening, because there's more insurance available and people tend to be better compensated. Because workers' compensation is statutory, the value of the case is, what benefits does the insurance company potentially owe in the future if you're trying to settle it? Or we can, and we assist folks in both pursuing claims to get benefits, disability benefits, new doctor, surgery, MRI, whatever, as well as trying to settle cases, and most cases do settle.
Question, you brought up something that I find interesting, the carpal tunnel, right? That might be over years of doing similar activity. What kind of, or as a result of working in a field, what kind of evidence or how difficult is it to prove that those injuries are a result of working in that environment?
It depends on a couple factors. How long you've been doing it. And some people are what we would call predisposed to getting carpal tunnel. In other words, some people can do repetitive type injuries their whole lives and never suffer symptoms. And then some people, if they do it for 6 months, they're going to start developing carpal tunnel. So one of the questions is, did you have carpal tunnel before? Because you can get it more than once. A carpal tunnel release surgery will fix the problem, but if you continue to do that type of work, you can get carpal tunnel again. So have you had it before? How long were you doing the work? What was the nature of the work? The more repetitive, the more likely carpal tunnel is, work related. And then the question becomes, who do they send you to for a doctor? Because there are some physicians who just don't think carpal tunnel is coming from repetitive injury or from traumatic injury. And
now, I'm sorry to cut you off.
I was going to say carpal tunnel actually can come from a traumatic injury as well, like a car accident back before the airbags were set so they wouldn't expand quite as fast at slower speeds. You'd have people getting wrist injuries that could result in carpal tunnel from car accidents, from impacts.
A workers' compensation claim, do they have to be a W-2 full-time employee? Or can they be a subcontractor? What are some things that might disqualify somebody from pursuing a claim against their employer?
A lot of employers claim individuals as independent contractors, and the question, and we'll do a 1099 them and then have an independent contractor agreement. But that's not the end of the analysis. I mean, you can still be an employee under that circumstance. There are employers who pay people on a 1099 and don't pay them overtime and don't pay them minimum wage, and that potentially could violate federal minimum wage, state minimum wage, and federal overtime laws. And so it's a much more complicated question. As a general rule of thumb, assuming your employer has more than 4 employees total, or is in the construction industry. For the construction industry, it doesn't matter how many employees there are, but as long as they're covered by the statute to where they would have to have workers' comp insurance, then somebody is an employee, usually is paid on a W-2, but not always.
Okay. And if somebody is being paid cash or under the table, would they have any type of recourse if they were injured on the job?
Yes. Again, assuming that they're covered by the statute. The fact that they're being paid cash doesn't matter. The one exception would be if the employer is using a staff leasing company to provide workers' compensation insurance. You may run into a factual scenario where the staff leasing company denies coverage because the person was never on the payroll for the staff leasing company, and then the employer has no work comp coverage. And we do run into a fair number of cases where employers just don't have workers' comp coverage when they're supposed to.
We see that kind of often sometimes where there's some overlap with our immigration clients who may be waiting for their work permit, or they are treated differently than American citizens at work and the employer doesn't want to pay them the full amount and gives them cash. So does somebody's status in the United States affect their ability to bring forward a workers' compensation claim?
As long as they never use a fake Social Security number or a fake name in the workers' compensation claim, they're entitled to the same workers' compensation benefits as anyone else. Sometimes it becomes an issue if the employer can show that they can't find work after an accident because of their immigration status as opposed to their physical limitations. So like if the employer had work for them and they could find other work within their limitations in their job field, but they just couldn't find a job because they got let go because they didn't have a Social Security number, and the employer didn't know that, that could result in some loss of temporary partial disability benefits. But again, as long as there's never a false Social Security number used in the workers' compensation claim, it's just a regular workers' comp.
I'm going to repeat that nugget of information for everybody who's listening. Okay, if you use a fake Social Security number, it will disqualify you from a workers' compensation claim. Now, as an immigration attorney, I'm going to take it one step further. If you use a fake Social Security number, a lot of times there's not a disqualifying act for a future thing or future process or future form of relief. However, the biggest mistake, what we call the kiss of death, oftentimes is when somebody makes a false claim to U.S. citizenship. And I don't mean you make a fake U.S. passport. I don't mean you do something. It could be as small as on a job application, checking a box that says, I am a U.S. citizen, here's a Social Security number. Because when you check that box, the employers do not need to request certain documentation from you at that point in time. So many people will make that fatal error so that they can work. And this will follow you forever in immigration law. And a lot of times there's little that can be done to undo that act. So for workers' compensation, no fake socials. Immigration, do not ever, I don't care what situation it is, make a false claim to U.S. citizenship or even to get a driver's license, sometimes registering to vote. These can all be considered false claims to citizenship. Sorry, Chuck, when you brought that up, it was a great point. I want to make sure
it comes up an awful lot. And if we have somebody who doesn't have a valid Social Security number, those are the first questions we start asking is, have you filled out forms? Have you signed documents? Have you provided a recorded statement? And the staff leasing companies are extremely good at getting those statements before those people get an attorney, and trying to get them to say that's their Social Security number. And the saddest part of it is you can apply for and get a tax ID number that's essentially a Social Security number, whether you're a U.S. citizen or even allowed to work. You can still get that number, and then you're paying taxes. And then the IRS wants you to be paying taxes, so they'll give you that number. And then using that number in a workers' compensation claim is not a false, false identification.
Same thing, even like a tax ID number for work, and instead of no claim to fake U.S. citizenship, there's no penalty for that, right? Even working without status, the penalties are not as severe as a false claim to U.S. citizenship. So part of the reason I bring, somebody like you with over 25 years experience in the field is to help educate our community. I really try to harp on, knowledge is power, and there's small things that people can keep with them to avoid not being able to pursue and to protect themselves, essentially, because ignorance of the law is not a valid defense, as we know.
Yeah. So
besides
never use a fake Social Security number in a workers' compensation claim. Just
don't. That sounds like that might be like one of your answers to my next question. But besides the social, what is the next worst mistake somebody can make that would affect their workers' compensation claim?
There's actually an affirmative duty in Florida statute 44105 and 44009 that puts a duty on an injured worker to actually provide information, whereas essentially making fraud broader in a workers' compensation scenario than in general in most circumstances. So if you have somebody who's had a prior accident and a prior injury, especially if they've had significant treatment for it, they have got to disclose that to the doctors. If they have a subsequent accident or a subsequent injury and start treating for it, they got to disclose that to the doctors. And simply not disclosing information can actually be the basis of a fraud allegation by an employer carrier. And then it becomes an issue of whether or not this was an intentional omission to obtain benefits or not. And then it's a judge issue, and you never know what's going to happen.
Chuck, we have a question from our audience here. It says, Iman has a question, is a 19-year-old able to have a tax ID number?
I believe anyone can, as long I would assume you have to be 18 to get a tax ID number, but I don't know the answer to that. But most accountants or CPAs can assist individuals in applying for to get a tax ID number.
And then there's another one. I think this might be outside of your scope. Is the tax ID number DMV can take with it for the driver's license?
I don't
think the tax ID is going to get you a driver's license. Florida has an acceptable tables document. If you search DMV Florida, DHSMV Florida, you could see what is required to get a driver's license or a Florida ID. I think what Chuck is saying, and you can correct me if I'm wrong, is use a tax ID number to file your taxes. If you're being paid cash and you want to report your taxes to the U.S. government, you can use a tax ID number and file your taxes. But thank you, Iman, for the questions. And if anybody else has any more, we'll be happy to take them.
And I was going to say, with the Social Security number, technically in Florida statute chapter 440, it's actually a crime to use a fake Social Security number to get a job. Whether or not that portion of the statute is constitutional or not is another issue, but they actually put that in the work comp statute, making it a crime to provide that to get employment. However, the distinction is it doesn't kill the work comp benefits, doesn't kill the claim unless it's actually used in the claim.
Okay.
So there are times where people have to plead the fifth about using a false Social Security number to get employment, whereas they can still testify in the rest of the claim about, not using any Social Security number in the claim.
So I have a question. You've been practicing law for over 25 years. How did you manage to keep your hair all this time?
It's getting thinner. So, being an attorney, as you know, is stressful. So, but I think this is probably more genes than anything.
Yeah, probably. Thank you. That helps. But so I see here that you are married and you have 3 children.
Yes.
Any plans for Halloween? Any major Halloween costumes?
See them behind us. I think my daughter is going as a little devil. My son is going as a knight, and then my other son has some weird costume that. He's going as a Japanese shogun, I think.
Okay.
So.
Well, I really appreciate you taking the time to help educate us. And how can anybody, if they have questions for you, how can they reach you? And I can post it up here. How can you share your phone number, or what's the best way to reach you?
The office number is 407-270-4500. And then the easiest email to reach me at would be chuck@cwsmithlaw.com.
Okay, is that right?
That is correct.
Okay, so there's Chuck's information. Over 25 years, obviously knows what he's talking about. All of my simple questions were leading to very complex, multiple scenarios, and that's how you know somebody knows what they're talking about. If it depends, right? So,
right.
I hope everyone has a wonderful and safe Halloween weekend. Again, happy birthday to my big brother. And we'll see you guys soon on Facebook Live. If you want more information on Workman's Comp or anything, just let us know or suggest a topic for next time. And Chuck, thank you again.
Yes. Happy Halloween. Thank you, everybody.